We left off at a new section in your historical outline, which is the Dominion Provincial Arbitrations of 1890, beginning on page 204
Yes,
of your slide deck.
yes, that's right.
So can you take us through that?
Yes, so representatives of all three governments, the Dominion, Quebec, and Ontario, met on the 28th of November, 1890, to discuss, among other things, the unsettled condition of the accounts of the old province of Canada. And they agreed to recommend to their respective governments that arbitration be undertaken to resolve a number of questions, which would include the claims made by the Dominion government on behalf of the Indians and payments made by that government to Indians. The arbitration would also, quote, apportion the liability of Ontario and Quebec as to any claim allowed the Dominion government, and to apportion between Ontario and Quebec any amount found to be payable by the said government.
Slide 205.
There were to be three arbitrators. One judge would be nominated by the Dominion government and one by each of the two provinces, with any two empowered to make an award. They were not bound by strict rule of law, but if they did proceed on a disputed question of law, the award would be subject to appeal to the Supreme Court and JCPC.
Okay, so 206.
All three governments passed legislation to agree to this arbitration process in late 1890 and by mid 1891. It would be the spring of 1893 before the actual arbitration process began.
I just want to interrupt there to make it clear here that this arbitration then was not pursuant to section 142 of the Constitution.
That is correct. Yeah, it'd be authorized by the separate legislation in each government.
Thank you. All right, slide 207.
Yeah, this is something that kind of occurred around the time the arbitration was about to commence. On the 17th of June, 1893, Deputy Superintendent General of Indian Affairs, Lawrence Van Coonet, wrote to the Deputy Minister of Justice, E.L. Newcomb, about the Robinson Treaty claims, which he said will form, if they've not already formed, a subject for consideration by the arbitrators. And in this letter, Van Coonet reminded Newcomb about the clause that referred to Her Majesty's desire, quote, to deal liberally and justly with all her subjects, and the possibility of payment of, quote, such further sum as Her Majesty may be graciously pleased to order over and above £1 to each annuitant. And Van Coonet suggested that owing to the immense revenue derived from the sale of land and timber within the territory ceded by the Indians in the treaty territory, the amount of annuity might fairly be increased. And so the timing of his letter suggests that he thought that the arbitration should take this into consideration.
And slide 208. What became of that?
So Justice Newcomb acknowledged the letter just a few days later.
Sorry.
Or sorry, the Deputy Minister of Justice Newcomb acknowledged the letter on the 19th of June, 1893. He said, the point to which you refer will not be lost sight of, though it's very questionable whether the provision in these treaties to which you refer can be made the basis of any legal claim against the province of Canada. And
did he provide any explanation for that?
No, not to my recollection. Yeah.
Thank you. All right. And then 209.
Yeah, it was a few days after that Van Coonet received a communication from the new Minister of the Interior, Thomas Mayne Daly. Daly said he'd noticed that Van Coonet's health is failing and that he, quote, no longer had the vigor of intellect that he'd had in the past. His retirement was requested. Van Coonet protested that he was only 56 and in good health. He declined to comply, but was nevertheless forced out within a month.
Are you making a suggestion that there's any link between his being forced out and the suggestion that he made?
I have no evidence to suggest that. I just think the timing is indicative that there could be.
Right, page 210.
Here I've named the Dominion Provincial Arbitrators. Ontario's was the Honorable John Alexander Boyd. The Dominion's was the Honorable George Wheelock Burbage. Quebec's was the Honorable Louis Napoleon Cassault. And Cassault incidentally had acted as counsel to Quebec's treasurer during the 1870 Section 142 arbitration.
Thank you. Slide 211.
On the 13th of February, the Dominion Provincial Arbitrators ruled on the so-called third award on Indian Robinson treaties, Huron and Superior, and other questions.
Can I just interrupt you there?
Yes.
You did tell us before that this Dominion Provincial Arbitration dealt with matters other than just the Robinson treaties. Is that right?
That is correct. Yeah.
So I'm wondering why we're jumping to the third award.
Because not all of them are relevant to the point at hand.
Thank you.
With respect to the Robinson treaties, the arbitrators ruled in paragraph 1 that, quote, if in any year since the treaties in question were entered into, the territory produced an amount which would have enabled the government without incurring loss to pay the increased annuities, then such tribes were entitled to such increase not exceeding $4 for each individual. And I just note here that they make no mention of the clause referring to such further sum as Her Majesty may graciously be pleased to order.
Thank you. And then you carry on, I see, with that same third award on slide 212.
Yes, so paragraph 2 specifies that the total amount of annuities to be paid under each treaty is to be ascertained by reference to the number of Indians from time to time belonging to the tribes entitled to the benefit of the treaties. That is, in case of an increase in number of Indians beyond the number named in the treaties, the annuities, if the revenue derived from the ceded territory permitted without incurring loss, were equal to a sum that would provide $4 for each Indian of the tribes entitled. So what I take this to mean is that the award placed no cap on the number who might be paid if the population came to exceed the numbers at the time of the treaties in 1850, as long as it came into without incurring loss.
Thank you. So
Can you, I just have a question.
Yes.
On paragraph 211, or sorry, slide 211. You have in the middle of the page, the arbitrators ruled in paragraph 1 that, and you have a quote.
Yeah, can we go to slide 211, please? That if, yeah.
Okay.
Uh-huh.
Is that just, are those just the words of the treaty?
These are the words of the arbitration award.
Yes.
So this is what they said. I would have to refresh my memory about the terms of the treaty that I'm quoting from the arbitration award. I mean, the idea is certainly.
I should have said, do they introduce any new ideas?
Oh,
Or is this just a summary, their summary of what the treaty says in your mind?
It is a summary of the treaty language. I
And they
think.
just stop before saying, or such further sum as Her Majesty may be graciously pleased to order.
Yes.
why don't we look at your report where you mentioned this to see if we
Okay, yeah,
have,
I should
if
just
there's a
see
bit
if
more
I
detail
provide more
there.
context there.
Otherwise, we can pull that document up. So it's discussed at your award, or sorry, at your page 166, and I can ask
Sorry.
my colleague here to bring it up.
Paragraph 1.
we'll take a moment then to
Yes, please.
find the actual
Yeah.
document.
Or do you have the report?
I guess, sorry. Your Honor, I should maybe specify the language isn't identical to the treaty insofar as it says to pay the increased annuities.
Right.
That's, I guess, what I should have made plain. That this is really in reference to consideration of payment beyond the level currently prevailing.
Thank you.
Yeah, does that clarify the point? Does that-
I just wanted to know if you were commenting on any introduced ideas or just that, see, you use the word ruling.
Yes.
Did they make a ruling or did they just state this as a fact? This is
Um,
what the treaty says.
Well, this is the third award. The proceedings. Yeah, no, I'm sorry. It did say they ruled in paragraph 1 of the third award. So I think this is indeed their ruling. Yeah, I'm sorry. The language on my slide differs from the language in my report. I say in my report, with respect to the Robinson treaties, the arbitrators ruled in paragraph 1. And then the quoted passage.
I can,
Oh, I'm sorry. No, I guess I do say that on my slide. I'm sorry.
I've got it.
Yeah.
I'm comfortable with what I needed. Thank you.
I think we actually have the document now. do we?
Okay.
It's in the joint book of documents tab 1765. And it's only a 30-page document, so we can probably scroll through and find. Did we actually, let me see if there's a particular page. number.
It seems to be,
11
oh.
and
okay, sorry.
pages 11 and 12, I think.
Yeah, my page numbers will be different because they're not from the joint book of documents.
Okay, can you slow down now here? Because here's 10, keep going then. And then if we go to, okay, can we stop here? No, that's the interest one, so keep going. Going. Here we go, page 11. And if you go down a little bit further, keep going. Here we go. So this is the award of the 13th of February, 1895.
Yes.
Can you please scroll through it for us? Thank you.
Yeah, I think we could, sorry, yeah. No, keep going. Yeah, we should keep going, sorry. And
Okay, here we are.
yes, there we are. So we can see one, the language of the award is that if in any year since the treaties, or I'm sorry, I should have started before, in respect of the claim made by the Dominion of Canada against the provinces of Ontario and Quebec in reference to the Indian claims arising under the Robinson treaties, that if in any year since the treaties in question were entered into, the territory, thereby ceded, produced an amount which would have enabled the government without incurring loss to pay the increased annuities, thereby secured to the Indian tribes mentioned therein, then such tribes were entitled to such increase not exceeding $4 for each individual. So I guess my point would be what's under consideration here is the increased annuities beyond the prevailing level to the limit of $4 per individual.
So what do you say they're saying about the claim of the Dominion against Ontario and Quebec? Are they saying anything?
I think not yet, but they do in this third award come to that point. I think in this moment, what they're saying is that they're dealing with the issue of population, right?
It comes up, I
sorry.
think, on slide 213, you tell us it comes up in paragraph 4, but maybe we could just go through until we get there. So,
I'll go ahead.
great.
Okay,
So
all right.
I think we're now on slide 212, where you talk about paragraph 2, which incidentally is on the screen right in
Yes,
front
I'm
of us.
sorry. Yeah, I've got that. That's.
So I
I'm
think
sorry,
you've already,
I misspoke. It wasn't yet dealing with population. It was dealing with the cap per individual. And so paragraph 2 on, if I can get slide 212, please.
I think we actually have already dealt with slide 212
Oh, I'm sorry, had we?
in any event.
Oh, yes, I think we have.
Yeah.
Yes.
I think
Yes.
if it's all right, we'll leave this document up on the screen, tab 1. Joint book document tab 1765 we'll leave on the screen for now, because I think we'll come back to it and
Okay.
just ask that the people work with the hard copy of the slides.
Okay.
So then on slide 213,
Okay.
you get into the question about liability.
Yes, that's correct. Yeah. So with respect to that question, they ruled, the Dominion Provincial Arbitrators ruled in paragraph 4.
And here, can we scroll up, please, to show paragraph 4 on the screen?
Now I, in some case, no, I guess I've included the full thing in my slide here so we can read from the text itself, if that's better. Or to number 4, so the other direction. Yeah. Yeah, there we are.
That's what I think.
So they ruled that any liability to pay the increased annuity in any year before the union was a debt or liability which devolved upon Canada under the 111th section of the British North America Act. I should say here, they're saying union in the sense of confederation. And that this is one of the matters to be taken into account in ascertaining the excess of debt for which Ontario and Quebec are conjointly liable to Canada under the 112th section of the Act, and that Ontario and Quebec have not, in respect of any such liability, been discharged by reason of the capitalization of the fixed annuities or because of anything in the Act of 1873, 36 Victoria Chapter 30. And so I would remind the court that the Act of 1873 was the increase in the provincial debt allowances, and the capitalization was that $88,000.
And this again is liability for the pre-confederation amount.
Correct. Yes. Yeah.
So then,
Could I just make sure I understand this?
Mhm.
So in the second line of this quote said, which devolved upon Canada. And so that is the liability under the treaties evolved, we might say, to Canada
I think
at
that what,
Confederation.
I'm sorry. Yeah, I think what they're saying here is that the debt of the provinces under section 111 was devolved upon Canada. And this was offset then by 112, which then sets a limit on the amount of liability assumed by Canada at 62.5 million,
Mhm.
subsequently increased. So this is how I understand it, that the annuities to be paid were one of the debts considered that was assumed by the Dominion government, which was in turn subject to a cap. So for
This is what I'm, this
yeah.
is where I'm confused.
Yeah.
If the liability, the liability was, I'm not sure what devolved means.
Mhm.
Was it inherited then by Canada?
I think what
Because if
Mhm.
that's the case, that's how I originally understood it, then why would it be added to the debt from one of the provinces? The debt account.
so what was added to the debt account was a capitalized amount to pay the annuities in future.
Mhm.
And that was part of the pool of province of Canada debt
Yeah.
assumed by the federal government under section 111. That debt was assumed, but it was assumed subject to the provision that it was only up to a $62.5 million cap, and the province of Ontario and Quebec would jointly be liable for anything that exceeded that.
So that's not my
No,
confusion.
not-
My
no.
confusion is, did it be, so that, what you have just explained
Yeah.
suggests that it was the province of Canada's responsibility. And then after the union, that responsibility got apportioned as between Ontario and Quebec. Am I wrong there?
I wonder if it'd be helpful, would it be helpful to look back at section 111 and 112? Or that not where
Yes, but
your
I,
confusion
that's not where I'm
lies?
stuck. What I'm
Mhm.
stuck is on devolved, what I take it from
Mhm.
reading this is they're not saying that that becomes now and forever a Dominion liability or responsibility.
Well, I think what they're saying here is the liability did devolve upon Canada under section 111. It
Mhm,
says Canada assumed all the debts of the
Mhm.
province of Canada. But it goes on to say, this is one of the matters to be taken into account in ascertaining the excess debt under section 112. So
Mhm.
it's saying, although the Dominion or the liability devolved upon the Dominion, under section 112, the Dominion then goes and collects it back from Ontario and Quebec.
So this is talking about money matters
Yes,
only,
yes.
not
What
about
I'll-
who's responsible under the treaty for instance, whether there were other matters under the treaty that what I would have called originally the Imperial Crown was responsible for. It's just the, it's
Just the
I
money.
think the money
money.
matters. Yeah, I'm sorry. Yeah, I do think that it's best understood as just dealing with the money matters. That's
Okay.
how I understand it, because that's what section 111 and 112 dealt with, right?
And
Okay.
And perhaps in the beginning phrase of that section 4, that any liability to pay the increased annuity might suggest that we're just talking about
Mhm.
the money matters.
Mhm.
Can we then move on to, I think you do deal as well with, with paragraph 5 about interest. You deal with that? Yes,
Yeah,
you do.
just a simple one. The interest is not recoverable upon any arrears of such annuities. That's paragraph 5. Paragraph 6.
Paragraph 6 is
sorry.
a particularly important one for this case. So I'd like you to take your time in taking us through that paragraph 6 and
Okay.
explaining it for us.
Okay. In paragraph 6, I guess should I read that then?
I
Or-
think that would be helpful.
Oh, Justice.
I'm always hoping you say it in your words,
Okay.
if you can.
Yeah, in some instances I can. I think, Your Honor, in this instance, I'd prefer to read maybe my excerpted part of it, if that's acceptable.
Certainly. Go ahead.
Which is that the Dominion provincial arbitrators ruled that the ceded territory mentioned became the property of Ontario under the section 109 of the British North America Act, subject to a trust to pay the increased annuities on the happening after the union of the event on which such payment depended, and to the interest of the Indians therein to be so paid. They said the ultimate burden of making provision for the payment of the increased annuities in question of such event falls upon the province of Ontario, and this burden has not been in any way affected or discharged. So I think what I would say about that is the event in question is the territory yielding sufficient sum to enable increased annuities to be paid without loss, increased annuities up to $4 per person. But what's different, I suppose, about this ruling is they are now saying that for the post-Confederation amounts that might be due for the annuitants, that these are a section 109 trust and not to be considered part of the Section 111 debt as the originally provided for annuities were. So this is in a sense, a departure from how the annuities were dealt with at the time of the 142 arbitration.
Justice Hennessy, would it be helpful to go back to section 109?
I'm just going to read this one more time and maybe yes.
Mhm.
Okay, thank you.
You're okay.
So yeah, that referring to post-Confederation amounts. Yeah.
So we're now
Mhm.
on slide 216, where you briefly summarize the other parts of this third award, which are probably less relevant until we get to paragraph 9. So why don't you go through that slide 216?
Yeah, so, yeah. Yeah.
Well, maybe I'll just read back or tell you back what I understand your third point, Terry, where you begin the ultimate burden. This, I understand that to mean post-Confederation amounts of any increased annuities are the ultimate burden of Ontario.
Yes.
Thank you.
Now we're on 216.
And just a couple of, as we heard, a couple of minor points that post-Confederation interest was not recoverable. That they also, this is kind of important, I suppose, that paragraph 8, they said that they proceeded upon a disputed question of law, which means that this ruling is open to appeal in the courts, was open. In paragraph 9, the arbitrators indicated that the amounts for increased annuities that had already been paid by the Dominion since the Union are to be charged against the province of Ontario. I'm sorry, I should clarify, I'm talking about post-Confederation amounts here, are to be charged against the province of Ontario in the province of Ontario account as to the date of payment to the Indians, and so fall within and be affected by our previous ruling as to interest on that account. There's a dissent among the arbitrators about interest, or about the date at which the payment should be charged.
Mr. Messamore,
yeah.
other than that dissent on that issue,
Yeah.
was this otherwise a unanimous decision of the 3 arbitrators?
Yes.
Now I see on slide 217, you summarize some key points
Yes.
from the submissions that were made.
Yeah, from the submission. So here we're moving back to think about what went into that decision. Now, I'm not sure. This is derived from 500 pages plus of transcript. So I've just pulled out some points from it. I guess one point being that Curran for the Dominion responded to Ontario's submission by saying that the minimum number of treaty claimants was fixed, but not the maximum. So, and also that flowing from that those who were in good faith members of these tribes are entitled to receive the benefit and to the increase not to exceed $4 for each individual Indian.
I assume then that this is in responding to a submission by Ontario. What would Ontario's submission have been on
Yeah,
that
so
point?
their submission would be that that the number as set in the treaties was the number that had to be adhered to.
The number
And,
of,
I'm sorry, the number of individual annuitants. There was provision, as the court will know, to what might happen if they fell below a certain level, but not any stipulation as to how high, sorry, that number could go.
You're
And-
saying Dominion Council argued, I'm not, that's not a finding, argued that,
That's exactly right, yes.
that the maximum number of annuitants was not fixed.
Correct.
That was contrary to an argument or a submission made by Ontario
Yes,
that the maximum number of annuitants was the number in the treaty.
yes.
and can you remind us what, in fact, the arbitrator's decision was on that point?
That the number was not fixed.
That was dealt with, we're kind of going backwards because we
Yeah,
went
that's
from your
right, yeah.
decision and now we're going to what the submissions were that led to it.
Correct.
So you
yeah.
told us before on slide 212 that the
Yeah.
decision of the arbitrators was that there was no cap on the number of annuitants due annuities. And all right, so I think we can then move to slide 218.
This might be relevant. Justice Burbidge inquired how it was that after 1874 increased annuities came to be paid. And essentially the point here is that all parties agreed that there had been a surplus sufficient to make these payments. This is something that Robinson for the Dominion said. He said they paid, I believe, because they had reason to believe there was a surplus. Ontario's Premier Mowat and the Federal Minister of Justice, Edward Blake, agreed there had been a surplus. Robinson also said, and again, this is not the ruling, this is counsel for the Dominion saying Ontario had the custody of the land, knew the resources. Ontario tells the Dominion, whatever the liability is, certainly there's money enough here to pay the Indians, and we think they ought to be paid. The Dominion say, certainly then we will pay them because that is of great importance. We will settle our own differences afterward. Now we have come here to settle our differences.
Slide 219.
Robinson for the Dominion in his submissions also rejected Ontario's contention that the Section 142 arbitrators award, I'm sorry, I've got a typo here. It should say in 1870. I wrote 1873. I also made the same mistake in my report. It should say 1870. We know that was the date of the Section 142 arbitration. Robinson rejected Ontario's contention that the Section 142 arbitrators award relieved them of any obligation. He agreed with Quebec's argument during this Dominion provincial arbitration that if the award intended in any way as saying that the land should be freed from any charge and so on, if that was intended to affect the construction of the BNA Act, Section 109, that would be ultra vires. The arbitrators could have no authority to decide upon the construction of that act or what it means.
And in your first point, you say that the Dominion's Council rejected Ontario's contention that Section 142 award relieved them of any obligation.
I'm sorry, relieved Ontario of any obligation.
Got it. Thank you.
And the ultimate award of the arbitrators on that point, you had summarized for us at 213. Can you tell us again what the arbitrators award was on that point?
Yes, so the arbitrators award said that,
Actually, again, I think I might have led you to the wrong.
oh, no, wait a
Oh,
minute.
on the point of whether the arbitration relieved obligations.
Yes.
Yes, I
I'm
think it was
sorry.
213.
Mm,
And again, 215.
Yeah, they ruled that any liability to pay the increased amount in any year before the union was a debt or liability which devolved upon Canada under the 111th section of the British North America Act 1867, and that this is one of the matters to be taken into account in ascertaining the excess of debt for which Ontario and Quebec are conjointly liable to Canada under the 112th section of the Act, and that Ontario and Quebec have not, in respect of any such liability, been discharged by reason of the capitalization of the fixed annuities or because of anything in the Act of 1873, 36 Victoria, Chapter 30. So point being, this is again with respect to the pre-Confederation amounts, that nothing in the arbitration relieved them of any additional obligation by virtue of the fact that what was to be paid in future was capitalized, or by the fact that the debt allowance was subsequently raised.
And I'm sorry, Professor
Um,
Messamore, I think I might have taken you to the wrong slide, because that of course deals with the pre-Confederation amount.
Right, and
But
then,
really it's the post-Confederation amount, which you dealt with at the bottom of page 215 of your
yes, you
slide.
mentioned slide 215, so I was going to turn to that one next, which is that the ruling was that the ceded territory became the property of Ontario under the 109th section of the BNA Act, subject to a trust to pay the increased annuities should the territory yield sufficient revenue, and that the ultimate burden of making the provision for the payment of the increased annuities in question in such an event falls upon the province of Ontario. The burden has not been in any way affected or discharged.
Just hang on a minute here.
Yeah, I'm sorry.
Thank you. I had wondered whether the award was specific about the burden having not been affected or discharged, whether there was anything more specific there, but there isn't. So thank you. I think we can then go back to slide 220.
229, or sorry, 220, yes.
220?
220. Yeah, in paragraph, I'm sorry. Irving raised another point, and again, I'm talking about the submissions made before the ruling, or Irving for Ontario, Ontario's council, said in the event of the migration of the said Indians or of any band of the said Indians to other territory, Ontario claims to be entitled to the reservations deserted by such Indians or bands. And Chancellor Boyd protested that that matters not before us now, is it? He added, this is sort of a cross claim you make, and has such a question arisen yet? Irving acknowledged that it had not arisen. So Boyd answered, this is a prospective claim. Are we to deal with these? This would not be a matter entering into the adjustment or taking of the accounts. It would be a matter of subsequent discussion or litigation or whatnot, when the Dominion was claiming these reserves which had been abandoned. No such case has arisen. We should not deal with a hypothetical case. It may never arise. Now, on the slide that follows, 221, I just say that my interpretation of this, it suggests that the Dominion provincial arbitrators took a limited view of the settlement they were being asked to make, that it was only to apply to the circumstances as they then existed, the immediate problems under contemplation, and not to future hypothetical situations.
Thank you.
There
Slide
a
222.
couple of other points. Yeah, 222, again, from the submissions made. Ontario's Irving, turning to the question of the Dominion's assumption of provincial debts and liabilities at the time of Confederation drew a distinction between debts and liabilities, and he cited a definition in a law dictionary. He said, "My point is that all the debt of the late province of Canada was settled by both parties, by all parties, settled and submitted to the arbitrators, and that with reference to it, without at all considering the matter further, that the 88,000 then taken in was a finality." So I suggested in my comments on this that it overlooks, Irving's argument overlooks the very important point that there was a precise limit for the amount allocated for each province for how much of their debt the Dominion was responsible for, assuming there was a limit for the Dominion's assumption of debts and liabilities, that debt allowance, and that the total amount of debt was not intended to be a finality, although the debt allowance was. So my point being that we talked already about how the debt accounts frequently had new amounts added and deducted from them as new information came forward on things. So that debt amount, it's never consistent, but the debt allowance is consistent. So I think Irving's interpretation would not be generally accepted.
So on slide 223, you get into another point
Yeah,
you'd like to make about this arbitration.
right. The arbitration touched on, the discussion touched on the transfer of responsibility for Indigenous affairs from imperial authorities to colonial ones under the Imperial Act, the 23rd of Victoria, Chapter 151, which was in 1860. And Irving said, it is to be inferred, Irving for Ontario, it is to be inferred that there was no debt then due by the province of Canada to the Indians, because the Crown, either by its representative, the Governor General, up to 1861, the Governor General as the imperial officer with his superintendent, or after that, had not put forward the claim, and is not to be assumed that they would have neglected their duty. Boyd, Chancellor Boyd, said, one would think if they turned over the control from the imperial power to the provincial, that they would see that there was nothing to be cleaned up then, that they would make a clean slate when they were turning it over so that there were no arrears.
And just to be clear here, you're talking about the responsibility for Indigenous affairs here.
Yes, that was turned over in 1860.
So you're not talking specifically about annuities. in this.
No, and it's in some ways somewhat confusing because the imperial government was not paying these annuities that we've been discussing. The provincial government was paying them. I suppose what he probably means is that because the imperial government was intended to be a sort of disinterested arbiter to protect the interests of Indigenous communities, if it was thought that local legislators would not, that somehow the imperial government would have taken responsibility before handing over responsibility to make sure that there were no outstanding matters. I, on my next slide, have,
224.
so 224, sorry, have noted the irony in this confidence that any outstanding matters would have been discovered and dealt with before the imperial transfer of responsibility for Indigenous affairs to the province of Canada. And it's ironic, I think, because such steps weren't taken when responsibility for paying the annuities moved from the province of Canada to the Dominion. They didn't ascertain that the correct amount was being paid. They didn't ascertain what the yield of the territory was or anything else. So I just note the point that they're saying, well, surely the imperial government would have dealt with all of that and made sure everything was being done properly. Evidently, they had not.
So this is a matter of your own commentary.
It is strictly my own commentary.
And what you're saying on slide 223,
Mhm.
you're talking about a transfer of the bureaucracy in
Correct.
1860.
Yes.
So Boyd says, as I understand this, one would think that who's they again?
I think, yeah. I
If
think-
they turned over the control from the imperial power
Mhm.
to the provincial, they would have seen there was nothing to be cleaned up.
I think he must mean the imperial government insofar it was a piece of imperial legislation.
All right, so Boyd is arguing that before the transfer of the bureaucracy,
Mhm.
the imperial crown would have done their diligence to make sure everything was clean and neat before they
think-
handed it over.
I think that's correct.
I think that takes us to slide 225.
Yes. So, again, we're thinking about submissions made prior to the ruling. J.M. Clark for Ontario made some relevant remarks on the question of a trust existing under section 109. There was a discussion of whether there was a distinction in this respect between the annuities as paid at the time of Confederation and augmentation based upon the yield of the territories. And Justice Burbidge, it emerges from this exchange, saw these amounts as distinct.
Let's
And I-
turn over to
yeah,
page
to
226.
226.
This is the transcript from
It
the
is.
submissions.
Yes, yeah. So Justice Burbidge saying, again, thinking about the amounts up to Confederation and subsequently, he said they were not exactly the same. They had to pay those whether they ever got anything from the land or not. There is just that difference. One thing they had to pay whether they ever got $1 from the land or not. And Clark for Ontario agrees. I think what he means here is the fixed annuity amounts had to be paid whether they got $1 from the land or not. And then Justice Burbidge says, it seems to me that one might clearly be of opinion that the fixed sum of £600, the right to receive that was not an interest or trust attaching to the land or in the land in any way, and yet be inclined to think that the covenant to pay monies in case the produce was in excess of the expenditure upon the land was one running with the land, not into whosoever's hands it came, because it could not be affected after it passed out of the crown, but in respect of whatever crown held it, that it attached to the land in possession of the crown, no matter whether it was the crown, whether that was the crown in right of the Dominion or in the right of Ontario. And I think this is giving some insight, I suppose, into the apparent inconsistency of the Dominion provincial arbitration, that they could see the payment of annuities based upon the original amounts as part of a section 111 debt. And that was capitalized for that, the amount of $88,000. And then you could simultaneously, in Justice Burbidge's view, call the additional obligation to pay amounts up to $4 in excess of what was currently being paid, that you could consider those a section 109 trust. That's how I understand his thinking here. It's not entirely clear how he's wording it, but he's making that distinction. And that explains, I believe, why he supported a section 109 interpretation.
I'm just getting mixed up here.
It is very confusing.
Partly, so Justice Burbidge is,
He's one of the.
he's one of the three,
One of the three arbitrators, yes.
but you say there's an inconsistency between what he said and the arbitration award.
Oh, no, I'm sorry. I didn't mean to suggest that. I meant, what I should have said is the section 142 arbitration treating future annuity obligations as debt under section 111. One might imagine then any subsequent amount should also be treated as section 111 debt. But Burbidge, or rather the three arbitrators, are saying, no, we're choosing to treat it as section 109 trust.
Right.
Yeah, I'm sorry, I meant to
That's
suggest
okay.
there was the inconsistency.
I think we do get back to that, what you call sort of this inconsistency later in your slides, so
Okay.
maybe we'll be able to
Okay.
revisit that. So in 220,
And sorry, can I just ask you
Yes.
to, if you're talking about an arbitration award, just name it either by
course.
year or by
Yeah.
something so that it's,
Yeah,
I
so
can,
could we say the section 142 arbitration
yes,
to that language? And I think in the report, I'm using the language Dominion Provincial Arbitration for the
Okay.
arbitration of 1890, but I could, or the 1890s. If it's easier to conceptualize, I could just refer to it the 1890s arbitrations,
great.
or if that's preferable.
Just, I'm
Yeah,
always reminding people that at some point I'll be looking at this and hoping that it's crystal clear.
yes,
Thank you.
yes.
so at slide 227, you speak again about that offsetting amount, the lower Canadian offsetting amount. And I think that this is a point that you've already raised and we've been through.
I think I have, unless there's questions about it, that the issue of there being an offset to the Robinson Treaty obligation, annuity obligation, in the form of a lower Canadian annuity obligation.
And I would
Um,
suggest that we go ahead to slide 230, because
Okay,
that's where we actually see on the transcript, the exchange about this
okay, yes,
offsetting
yes,
debt.
I agree. Yeah.
Can we start that 230?
So Chancellor Boyd sought clarification about the original capitalization of the annuities under section 142. Or sorry, following section 142. He said, did the capitalization of the debt which the Dominion of Canada assumed include both the 4,400 in Upper and Lower Canada, or only the 4,400 of Lower Canada? Hogg said it included both. The Chancellor asked what was capitalized. Justice Burbidge said the debt was increased by two sums of $80,000 and $88,000. The $80,000 represented the capitalization of the $4,000 of Quebec. Irving said it was substantially capitalized. Chancellor Boyd then said, then they took the annual charge payable to the Indians in both provinces, rolled them together into one liability, and distributed them in the proportion of 4/9 to Quebec and 5/9 to Ontario. So Ontario now bears 5/9 of that sum, which is paid to every Canadian Indian. So I guess that's a summation of how the Dominion provincial arbitrators understood the process of including both Robinson Treaty and the Lower Canadian annuity obligations as debt.
So can we move on then to slide 231? We're almost coming up to your comments on all this, but here on 231,
Yeah, I think this part is simpler.
mhm.
The Dominion provincial arbitrators in the 1890s did not offer an in-depth explanation of why why in their judgment, they used the phrase not exceeding $4. It does not appear that they gave consideration to the treaty phrase such further sum as Her Majesty may be graciously pleased to order. Throughout the proceedings, the sustained assumption by all seemed to be that only payments to a maximum of $4 per person were under consideration. The statement of case by the Dominion, filed 5th of October, 1893, for example, uses such phrases as the full augmented annuity of $4 to each individual Indian, quote, and quote, the increased annuity of $4 per head, unquote, and does not allude to a further sum.
So at page, slide 232.
Yes, again, this is my summation of discussion throughout this 500-page transcript. And both Chancellor Boyd and Robinson
And Robinson again
I'm sorry,
is acting for,
Ontario. Gosh, I'm sorry, I'm getting, just,
I believe he was acting for Canada.
oh, I'm sorry, he's not on my, okay, I'm sorry, I have to go back. I've got to clarify this in my mind. It's not on my list of,
He's not on the list.
No,
he's
yeah,
not.
he was for
Sorry, that
Canada.
was,
Yeah, I was gonna say, I thought,
okay, I'm sorry.
It's
For the Dominion. But
um,
that should be checked.
Yes, sorry.
we have it on,
Maybe I should go to the page number in question, 182.
we have it,
I'm sorry. Okay, yeah, I'm sorry. Yes, yeah, so both Chancellor Boyd and Robinson for the Dominion acknowledged the fundamental difficulty created by the decision to capitalize the Robinson treaties and to treat them like other debt obligations at the time of Confederation. And that was that capitalization might work for the base amount that was actually being paid at the time, but there was no way of capitalizing an obligation that wasn't fully understood. If they didn't know how much they would be required to pay and to how many people,
Mhm.
it is impossible to capitalize it. And that was something they acknowledged in the discussion.
And remind me, please, of when they made that decision to capitalize.
I believe it was, would have been, I don't think it was actually part of the section 142 arbitration. I think it was subsequent to that.
Okay.
I'm sorry, no, because it would have been before that, because they would have had to have a dollar amount of debt. So it would have been kind of $88,000 was arrived at as an amount of debt. And so in order to allocate debt under the section 142 arbitration, they would have needed to know how much that debt was, and that would be a capitalized sum. So of
And
course.
was
it would have
that decision a decision made unilaterally? Or was it made conjointly, or do we know?
I don't know.
Okay.
Someone
That's
may
okay.
know, but I don't.
this one is the one that it's fairly straightforward math, that the 88,000 comes from
Right.
4,400.
But the decision to capitalize, not how to calculate. The decision to capitalize it before going into the arbitrations. So the putting it on whose books was that, do we know? Is that a decision? So, because I'm reading this, acknowledge the fundamental difficulty created by the decision
Oh,
to
I see.
capitalize.
Yeah, my suggestion here is that the alternative would have been to not
No, I'm
capitalize.
just
but
saying,
to- oh,
who made the
yeah,
decision?
yeah.
Or do we know?
No, I don't know,
Okay.
but I believe that, I mean, all these ongoing obligations were capitalized, whether they be for pensions, other other annuities do, and indeed the Robinson Treaty annuities.
Okay,
So it seemed to be the standard practice, but I'm afraid I can't answer the question as to whose decision it was.
no problem.
Thank you. I just wanted to note at page, or slide 232, I looked at your report. The Robinson in question here is Christopher Robinson,
Okay,
who was counsel for the Dominion.
okay, yes, okay, thank you.
Do you know whether he was in any relation to William
I did not
Robinson?
investigate that question, yeah. At one point they call, in the transcript, they call the Quebec Treasurer Robinson, so that got really confusing, but no, I didn't notice that.
All right, so I think we still have time before the break to go through your thoughts on the arbitrator's ruling.
Mhm.
Is that, can we continue on for a few more slides? We'll be done this section in about 5 slides, I think.
So the Dominion provincial arbitrators in the 1890s decision to treat arrears for increased annuity amounts before Confederation as part of the province of Canada's debt to be charged to the province of Canada's debt account seems uncontroversial. The entire province of Canada shared in the benefits that flowed from that territory, and all parties seem to agree on this point. Annuity payments for the post-Confederation era are more complicated.
And here we're at slide 234.
I'm sorry, yes, 234. Consistency would seem to demand that the increased annuity amounts be treated in the same way as the annuities at the original level. Amounts to be paid in the year after Confederation were originally capitalized at Confederation and became part of the province of Canada debt. This debt was divided between Ontario and Quebec according to the 53-47 ratio. The formula was based on the known debts at the time. On slide 235, the 1870 section 142 arbitration was based on the decision about the origin of the debt, whether it was for a local or general purpose. Such a principle would seem to suggest that any debt associated with the capitalization of the Robinson Treaty annuities in the post-Confederation era would be allocated to Ontario, since Ontario alone would be deriving any future benefit from the revenues from that Crown land. But Ontario's council at the time of the 1870 section 142 arbitration argued instead that it was not quite that simple. They cited the substantial revenues that had flowed into the joint provincial coffers from other ceded lands, and with respect to the Robinson treaties, an offsetting annuity obligation for Lower Canada.
Just to clarify here, because we're going back and forth now between the Dominion provincial arbitration in the 1890s, and you're
Yes.
bringing us back to the section 142 in the 1870s.
Yes,
And I understand it's to show us what some might view as an inconsistency as to how they dealt with it.
that's correct. Yes, I think, let's see on,
Can you explain maybe explain that inconsistency before we go through the slides? It'll help put it in context.
because the Dominion provincial arbitrators in the 1890s chose to call the post-Confederation obligation for higher annuity payments up to $4 a section 109 trust, that was inconsistent with how they'd been treated at the time of the section 142 arbitration. The section 142 arbitration, Quebec had argued the annuity obligations should be a trust and not a debt. But ultimately, the arbitrators in section 142 arbitrators said, no, we can treat these as a debt because look, we have two exactly or more or less equivalent amounts. Does that answer the question?
I think that provides some good background. We'll continue to go through these slides then, just before we
Okay.
break.
Is
Yeah.
it fair to say that the section 142 arbitrators rejected the trust argument?
Yes, I think it is.
And on slide 233,
Mhm.
the point is that you're making is the Dominion provincial arbitrator's decision to treat arrears for increased annuity amounts before Confederation
Mhm.
as part of the province of Canada's debt seems uncontroversial. So the only annuities we're talking about are under the Robinson treaties, because you're talking about
in this-
increased annuity amounts.
Yes, in this particular case, yes, that's quite correct. This is only considering the Robinson Treaty annuities.
Thank you.
I think we go to slide 237, if that's all right.
Oh,
So-
actually, I think you were
oh,
still
I'm sorry, was I
on.
not, did I not finish that?
I-
Oh, no, you're right, I did not finish my point on 236, yes.
Yeah.
In fact, I don't think I started.
I don't think you started
236,
236 yet, so we'll go there.
So justice would dictate that any significant new amounts subsequently added to the province of Canada debt, which might affect the calculation of a fair sharing formula between Ontario and Quebec, ought to be carefully scrutinized according to the same principles that informed the original decision.
And this is your own opinion.
Yes, this is what, yeah.
When you say justice would dictate,
yeah.
this is your view.
Well, yes, this is my summary of what I understand, yeah. So since it was understood that Ontario alone would derive benefit from these crown lands in the post-Confederation era, it was difficult to justify placing any burden on Quebec for the payment of increased annuities in future. But it would be difficult to go back and recalculate the 1870 sharing formula based on this new information. The new information being, we thought they were equal obligations, actually they're not, right? That's what I mean by that. There did not seem to be any provision by which the 1870 Section 142 award could be reopened.
Can I just interrupt you there? When
Yeah.
you say we thought they were equal
Yes.
obligations, you're talking about,
In 1870, when they made the decision to use this offset principle and consider them both as common debt,
and why is this, what is this new information that means they're not equal anymore?
the fact that the payment for the Robinson treaties would be higher than first provided for.
It would be higher than the annual amount would be higher than what could be generated by the 88,000 capitalized fund.
Exactly so, yeah. It would be higher than what could be generated by it, and it was only, the decision was only made to include that in a common pool of debt because equivalent capitalization for Quebec payments existed.
So can we go back to this opinion of yours?
Yeah.
Ms. Evans said, so what's the new information? But what you were saying was,
In this slide we have in front of us, 236.
yeah,
Yeah, just that, that any new amounts that might affect the calculation of a fair sharing formula would have to be carefully scrutinized according to the same principles that informed the original decision about that sharing formula. And that was, of course, the local benefit principle, right? It was understood that Ontario alone would derive the benefit from the crown lands in the post-Confederation era. So it would be difficult to place any burden on Quebec or to justify placing any burden on Quebec for the payment of increased annuities in future. The difficulty is they can't go back. The Dominion provincial arbitrators or anyone else can't go back and recalculate the original 1870 sharing formula based on the new information that the annuity obligation would be higher. And there didn't seem to be a provision by which that 1870 Section 142 award could be reopened to consider this new amount. And my suggestion is that that circumstance explains the decision, the apparently inconsistent decision by the Dominion provincial arbitrators to treat this increased annuity obligation as a Section 109 trust. And they believe that it wasn't mutually exclusive. You could have one part of that annuity obligation flowing from Section 111 debt and an additional amount justified under Section 109 as a trust.
This
makes
is
sense.
just bringing us back. This is what Justice Burge's point was. You could look at those annuities as two different, in
Yes,
two different ways.
exactly. So, yeah, yeah.
Do we need to
Okay.
go back to that?
No, I
No.
just want to get to the very first point on slide 236. You're saying, as I understand it, Professor, that any new amounts, so any increased annuities,
Yes,
is that one way to put it?
yes, yes.
Added to the province of Canada debt, which might affect the calculation of, and you use these words that are sort of magic around here, a fair sharing formula between Ontario and Quebec. So, but tell me what you're talking about here. Are you talking about something that's going to happen in this trial?
No, no, I'm not. No, what I'm trying to do is understand the thinking
Okay.
of the,
Can I interrupt just to say, the fair sharing formula between Ontario and Quebec, what does that refer to?
what it refers to is the formula worked out under Section 142.
53, 47.
5347. Yes,
So when you write,
yeah,
Justice would that in your opinion, if there's to be any messing around with Section 142, it should be carefully scrutinized because you can't go back.
yeah. I mean, I guess I would say that you couldn't mess around with Section 142.
Okay,
Yeah, that it's.
don't
it's-
mess with Section 142. is
Exactly.
what you're
It's locked in. And that point comes up repeatedly. People say this is settled for decades. We can't reopen it. If we tried, the floodgates would have opened and all sorts of other claims would come in. It would be unworkable. So we can't revisit Section 142.
happily in this trial, I believe we don't have to.
So that takes us to the last slide I'd like to get to before the
This-
break,
yeah.
which where in your title, you talk about this as you say this difficulty may perhaps explain the apparent inconsistency of the Dominion Provincial Arbitrator's decision.
Yeah,
And
so
so
in
can you
slide
summarize this?
237, yes, I say this difficulty may perhaps explain the apparent inconsistency, which I just referred to in the Dominion Provincial's arbitrator's decision. And I mean inconsistent with respect to how annuities were treated in 1870. They decided to regard the arrears of annuity for the period after Confederation as a trust under Section 109, even though the amount originally anticipated for future annuity payments at the time of Confederation was treated as a debt under Section 111 and divided under Section 142. The Dominion Provincial Arbitrators were authorized to proceed according to equitable principles. So I guess that's my fair sharing formula, and not strict rules of law. They apparently accepted the principle that these revenues and expenses were tied, that the government that received the benefits should also pay the costs.
And
That-
can I also take it, it's your opinion that the two different treatments of the annuities, what you say appear to be inconsistent, you say they can't be reconciled. these different treatments or characterizations of the annuities
Well, I
can be
guess,
justified and or reconciled?
I think that part of the annuity was considered a section 111
Mhm.
debt, according to the three arbitrators here. And part of the annuity, in their view, could be considered a section 109 trust. This is
Right.
their view.
So you point out that that appears to be an inconsistency, but I'm coming to the conclusion, if you correct me if I'm wrong,
Mhm.
that you say that can be justified, that different treatment.
Yes, I suppose that is true. Yes, that it can be justified. And again, I don't want to weigh into the question of what is a trust. That's not
No.
my bailiwick, but this, I'm trying to understand the rationale that they used. And I felt that the fact that section 142 put them in a kind of straitjacket, they couldn't reopen it. They had to find a way to apportion this according to equitable principles between Quebec and Ontario. And the way to do that was through by considering the obligation to pay increased annuities as a section 109 trust.
And you say that this different treatment of them is consistent with the principle of obligations go with benefits.
I think so.
Thank you.
I think that brings us to a good time for a break. And it's apparent that we're not going to finish the entire slide deck today, but we are making good progress. And I think if we take a 15-minute break, we'll still have a good half hour to keep going through.
Okay, and maybe just over the break, you can let your friends know how much time you think you'll need tomorrow. Okay.